Good morning, everyone, and welcome to today's webinar on the EU Whistleblowing Directive 2 years on. I'm Rachel Mackey. I lead the account management team here at Safecall. I'm joined by Joanna Lewis, here sat next to me, our managing director at Safecall, Katherine Harle, partner at Dentons, and Sarah Partridge-Smith, senior associate at Dentons. In terms of an agenda today, we're going to start with just a quick overview of Safecall. Joe's then going to discuss Safecall's role and the experience in the landscape of the EU directive. Dentons are then going to discuss the EU Whistleblowing Directive and how it's been received and implemented so far, and also what the significance is to UK businesses. And then finally, at the end, we're going to have time for some questions. So please do submit those in the question panel on the right-hand side of your screen as we go along, and we'll get to as many as we can at the end. So just in terms of who Safecall are and a quick introduction. Safecall is a whistleblowing service provider. We were established in 1999, so over 20 years ago, and we offer hotlines, training, investigation support and case management software, along with e-learning. We cover over 50 million employees in over 1,000 organisations worldwide. You can see some examples of some organisations we work with below. We communicate in over 175 languages and dialects in over more than 150 countries globally. I think that's pretty much every language. And all of our call handlers have at least 25 years investigative experience, all being former police officers and similar roles, which is really important to us. So without further ado, I want to hand over to Joe. Joe, why did we want to discuss this topic today?
Well, I think given what you've just explained there about the sorts of organisations that we support, there are many who have multi-jurisdictional locations, so they're in lots of different countries. The majority we work with tend to be headquartered in the UK, but they will have global offices. And with this directive being introduced a couple of years ago now, and having been implemented at very different sort of stages and rates across the EU, I think there's a lot of interest in making sure that they're getting it right, basically. People want to make sure that they're adhering to the appropriate legislation. And I think as a whistleblowing provider, and you know this yourself, we're often asked for our kind of feedback and and our experience of this, and we're not the experts, and we're lucky enough to have partners who are experts. So we're delighted that Dentons have agreed to join us today because they are experts in this area, and who better to talk about it than people who live and breathe this all the time. So that was the main reason, I suppose, for doing this today, and we expect that that our clients and people listening will be will be more well educated by the end of it. But yeah, so that's why.
So why do you think that organisations choose to use Safecall?
Yeah, so I think interesting, and the feedback we ask our clients why they choose us and why they choose external whistleblowing providers specifically. And I think that I'll answer the second part first and then the Safecall bit. So I think people choose to use external providers, and we have been operating, as you say, for more than 20 years, so people chose to use us prior to any legislation or directive telling them to do so. So I think predominantly organisations generally want to understand what's going on, and want to understand if there's wrongdoing happening in the workplace, and want to do something about that. I think as well, another really important point, aside from legislation, which is clearly important and what we're here to talk about today, is culture. And organisations, again, and I'm generalising, but a lot of our clients choose us because they want to embed a really positive culture within their organisation. They want to be an employer of choice, and they want people to understand that when they work for their organisation, that they can speak up freely, and that they don't need to worry about what the outcome of that might be, so that they can create that sort of positive working environment that everybody feels happy and safe to come to work every single day. I think just to finish before I hand over to Dentons, I think the reason that people choose us, one of the reasons, other than the the things that they would expect to get, which is a great software system, you know, training and the ability for us to support investigations. It's what you were saying, that we are the only provider that offer former police officers as our call handlers, and those people are incredibly experienced in terms of their ability to deal with people in really difficult situations from all walks of life, putting them at ease and making sure that they get the best experience when they contact us. And that's really important to us. The quality and trust element is super important. And that's, you know, giving people that safe space to make that report and feel that it's going to be dealt with appropriately, I think, is the feedback that we get most often. But enough about Safecall. I'd really love to hand over now to Katherine and Sarah to talk a bit more about the directive. So thanks, guys.
Good morning, everybody. My name's Sarah Partridge-Smith and I'm from Dentons. If we could turn to the first slide, please. We're first going to start running through the Whistleblowing Directive and give you a high-level overview of what's required by the directive and how it's been implemented by member states before moving on to consider how it impacts what is happening here in the UK. So you'll see from this slide, the Whistleblowing Directive required member states to implement the requirements into domestic legislation by the 17th of December 2021. The regime was intended to apply to all public sector companies and private sector businesses with more than 50 workers, although the requirement for private sector companies with between 5 and 249 workers won't be fully operative until December of this year. The purpose of bringing in this directive was to try and encourage internal reporting and addressing of concerns by firms, rather than the reliance on external reporting to regulators and authorities, to enable those concerns or breaches to be addressed by firms in the first instance, to try to combat particularly financial crime concerns that were arising. In order to encourage that increased reporting and increased responsibilities by firms, it was felt there had to be measures put in place to encourage whistleblowers to report, and that included making sure that they could report and that they were comfortable in doing so, so by preventing the prospect of retaliation against them. We could move on, please, Brogan. There are conditions that are specified in the directive, and these apply across all member states, so there's no derogation in how this can be implemented. With regards to the conditions for protection, the member states can implement its own rules in relation to accepting anonymous reporting, and we will come on to that in due course. But you'll see that in order to qualify for protection as a whistleblower, you must evidence that there are reasonable grounds for believing the information reported was true or correct when reported, that reports were made through designated internal or external channels. So again, that places that reliance on the firms to put those channels in place. And where a report is made through public disclosure, so if the report wasn't made through internal channels, the following additional conditions apply to whistleblowers before they can benefit from those protections. So they must have attempted to report through their internal reporting lines. There must be reasonable anticipation of immediate endangerment of public interests, and there must be a risk of retaliation or low prospect of the breach being effectively addressed were that report to have been made internally. So really has to be a serious concern that it's felt that there was no prospect that it would have been dealt with had the reporting internally been conducted. We can move on, please, Brogan. This is what the Whistleblowing Directive ensures, and that's the protective measures for whistleblowing. So it makes sure that there can be no obstruction. So whistleblowers must not be prevented or dissuaded from reporting, including by threatening, intimidating or frightening behaviour. And that applies both to firms and to natural persons that work within those firms. Confidentiality. So with limited exceptions, a whistleblower's identity and that of any third party named in their report must remain confidential. And there is a difference again, and we'll come to it in due course, between confidentiality and anonymity. With respect to confidentiality, member states are putting in their own requirements individually in terms of the sanctions that can be imposed. But for example, Italy have codified the penalty for breaching confidentiality by firms with range of between €10,000 and €50,000 in fines for breaching firms. So retaliation measures against whistleblowers are prohibited, and we'll come on to how firms have implemented that. And there must be remedies, so there must be a way that whistleblowers can enforce those protections. We could move on, please, Brogan. Let's look at implementation. How are firms getting on? Well, the short answer is not very well. By the time the directive was required to be implemented, 17th of December 2021, only 5 of the 27 member states had successfully implemented it. That was Denmark, Lithuania, Malta, Portugal, and Sweden. There were significant issues with the timely implementation of the directive by a number of member states. And in particular, they complained that with the tight timeline, that they struggled to implement because it didn't give them enough time to consult stakeholders on issues such as transparency, freedom of information, and subsidiary reporting channels. And that delay in implementation was also caused by the differing maturities in member states. So while some states may have also only been required to supplement existing protections, others, such as Poland, didn't have any comprehensive legislation in place, so really had to build a framework from the ground upwards and get buy-in to do so. For other states, there's been specific concerns that have been raised. So, for example, in Spain, there were significant delays both in the implementation of the directive and still ongoing challenge to how it has been implemented from a particularly active group called XNet, who are concerned about data protection issues in terms of anonymous reporting. So whether the anonymous reporting mailboxes that Spain requires actually safely protect the identity of people using them. So what happened after December 2021? The European Commission got quite cross about it. They sent formal notice letters to 22 of the member states that had not implemented, and Denmark and Lithuania were also sent letters of formal notice despite meeting the deadline because of inadequacies. By the end of October 2022, so a full year after implementation, still only 5 further member states had adopted the directive. And for many member states, it's only this year that legislation has finally been passed. So there's still limited data and limited case law on how those are being implemented, how it's working in practice. And it will take some time to get that data through in real terms on the effective reporting and detection of serious misconduct as a result of these changes. So in terms of what the European Commission is up to now, in February 2023, it referred a number of firms to the European Court of Justice for failures to transpose. And there are still, you can see there, Poland and Estonia, who had not, until very recently, put in place measures to implement the directive, although Poland has just passed its bill and it's on its way to being enacted. Estonia in particular is likely to suffer. The European Commission is asked for €600 per day in fines until it implements, and it's due to go up to €2,340 per day for each day of the delay. So ultimately how much Estonia will be fined is still open for debate, but it may be resolved later on this year. If we could move on again, please, Brogan. So divergence between member states. How have member states implemented this? The directive sets out a list of minimum requirements for states, and so it's largely up to states how far in addition they want to take the framework and how far they want it to encourage whistleblowers and how far they want those protections to extend. And member states have adopted widely different scopes of protection, including different areas of law that are protected, and we'll come to that in due course. Some member states apply the protections precisely in terms of the directive to both public and private entities with 50 or more employees. So Bulgaria, Denmark and Germany have taken that approach. But other member states have taken a variety of approaches on applying the directive to public entities and local authorities. So, for example, in Cyprus, it applies to all public entities, regardless of the number of workers, with a de minimis exception for local authorities with under 5,000 residents or less than 25 employees. And in Latvia and Spain, it's extended it, so it applies to all public organisations, regardless of the number of workers. In some countries, such as Greece, they've removed the de minimis requirement for private companies as well for particular sectors. So financial services, transport and the environment, it applies to all private companies. In terms of who it should apply to and when that de minimis headcount should kick in, the directive is not explicit. So there is some contention as to whether the headcount threshold is assessed on the number of workers per member state or the number of workers operating in the EU in its entirety. So that will impact on those of you that have multi-jurisdictional states. Our provisional view is that the threshold should refer to the total number of workers within a legal entity, regardless of where such workers are based. And that seems to be the ordinary reading of the directive. So the remedies and penalties provided also differ between member states. Most have monetary penalties for breaches, but some, such as Denmark, Cyprus, Ireland and Greece, also have the possibility of imposing prison sentences for breaches of whistleblowing requirements and protections. And the number of required channels can differ by jurisdictions. So in many member states, there is one reporting channel required, but in Spain, for example, employers are required to set up a separate line for reporting instances of harassment. We could go to the next slide, please. So, as we set out previously, the directive requires protections to be put in place in respect to the disclosures of breaches of EU law. So that's quite narrow, but it can be applied more broadly by member states. And indeed it has been, with many states choosing to incorporate breaches of domestic law insurance requirements for whistleblowing protections. And we set out some of those here. So, for example, Germany extends the whistleblowing provisions to breaches of criminal law and certain administrative laws protecting life. In Spain, it's misconduct of public interest, so it's quite a wide provision. And in France, serious and manifest violations of an international commitment, which is very specific. And in Portugal, they are very concerned about the prevention of organised crime. And now again, just because we take it in three levels, we have the EU directive that sits at the top with the de minimis requirements. We have your member states that require another layer of de minimis or mandatory requirements. And then it's up to firms as well as to whether they want to go above and beyond what their member state requires. And certainly they don't have to limit themselves in this way. And we've seen a number of firms allowing whistleblowing complaints to be made in respect of any perceived misconduct within the workplace generally, rather than limited in the way that's been prescribed by the directive. Brogan, if we could move on, please. Turning to anonymous reporting. So the Whistleblowing Directive is focused on encouraging reports to be made of employees of firms confidentially and in circumstances where they are protected from mistreatment. And the directive leaves it open to individual member states to decide whether businesses and competent authorities are required to accept and follow up on anonymous whistleblowing reports. Whichever approach a member state takes, though, an individual who makes an anonymous report must be given the protection of the directive if they're subsequently identified and subject to retaliation. Confidentiality and anonymity are often conflated, particularly in whistleblowing in our experience, with whistleblowers often mistakenly believing that they have a right in all circumstances not to have their identity disclosed. In practice, it might be difficult to retain complete anonymity in whistleblowing investigations, particularly where information could only have ever been known by a small number of people. And sometimes there is a requirement for external reporting as well, or there may be serious allegations which require the disclosure of that. The Whistleblowing Directive doesn't require states to provide anonymous reporting mechanisms, and indeed in some states it's not permitted in the way that the directive has been transposed into domestic legislation. So if we have a look here, you can see on my red bar here, not permitted, Bulgaria, Latvia and Lithuania, they don't permit anonymous reporting for whistleblowing within their whistleblowing framework. And in Bulgaria, that prohibition was justified with the argument that anonymous reporting created a risk that channels would be used maliciously and that they might result in the submission of false and or large numbers of non-substantive reports. Now, that clearly creates a difficult position for firms that wish to apply standardised reporting channels, and it may be that multi-jurisdictional firms operating in these areas will have to consider local policies if they want to offer anonymous reporting at a group level. 5 countries are silent on the issue, and so it will be up to firms within those countries to decide what measures they wish to adopt, particularly if they work cross-border. In 12 countries, there is an express permission, but not a requirement for anonymous reporting to be put in place. So that's 17 in total that would require it, and that in those countries, the reports would be treated in the same way as if you had made a report through the internal channels, confidentially or anonymously. The yellow bar is the odd one, and that is those apply to a small number of countries and captures national laws where anonymous reporting is permitted, but where companies are not obliged to follow up or investigate anonymous reports, or where whistleblowers are subject to differing levels of protection than if they had reported confidentially. So, for example, in Denmark and Malta, persons reporting through an anonymous reporting line won't qualify for the same protections as the whistleblowers that have reported confidentially. And in Hungary, Finland and the Czech Republic, there is permitted anonymous reporting, but there's no requirement for companies to investigate and or accept them. But again, as I've said before, aside from those red bar countries, for the remainder, it will be up to firms to decide whether they go above and beyond the requirements within those states and expressly give those additional protections to those whistleblowers reporting in that way. So anonymous reporting is a key example of the areas of difference between member states with significant impact on the type of reporting channels that companies can adopt. We move forward one slide again, please, Brogan. I know this is a whistle-stop tour. Please do feel free to ask questions. This is the US whistleblowing regime, and I'm not going to go into this in too much detail. There are similarities with the EU and the UK, but there is one key difference in the way that the US approaches whistleblowers, and that's in terms of the reward program that it puts in place for whistleblowers, which some of you may be aware of. The whistleblowing regime there has created some huge sums of money for whistleblowers. There's recently been awarded of nearly $200 million, approximately £148 million to a single whistleblower, while the SEC since 2011 has awarded $60 million to whistleblowers after recovering $2 billion in fines. However, the 5,212 SEC whistleblowers in 2019, for example, only 8 received any award, while the CFTC issued only 16 payments in respect of the 1,030 disclosures received. So although that reward program exists, it's certainly not rewarding all whistleblowers as standard. And in the UK, certainly there is a differing approach to the payment of whistleblowers. And I'm going to hand over to Katherine to talk through that more.
Thank you, Sarah. So just to come on to, and next slide, please, Brogan, just to come on to the UK whistleblower regime so that we can have a look at what that is and draw out some comparisons. Interestingly, it was actually the UK regime upon which the European expansion of whistleblowing requirements has been based upon, because a lot of the UK domestic law is what the directive is now looking to implement as a baseline for other countries in Europe. So there's a sort of 2-layer regime in the UK, depending on which sector you're in. So firstly, you've got, as I've set out in the slides, we've got the minimum standards that apply to all businesses across the UK, and those are set out in the Public Interest Disclosure Act, PIDA. And also from September 2016, for those banks and insurers and large investment firms who are regulated by the FCA and the PRA, there are some additional requirements that apply to them. Those are set out in the CISC 18 part of the FCA handbook and in the PRA's whistleblowing rules. So just to expand a little bit on each of those areas, in terms of the protection under PIDA, what this provides is that for a whistleblower, they have protection were they to suffer any form of dismissal, detriment or victimisation as a result of having made a protected disclosure, and their protection is their right to bring a claim in the employment tribunal. But that is, PIDA is quite limited in what it does. It doesn't prescribe how firms should establish whistleblowing process or even require that they do so. It doesn't prescribe how firms should receive whistleblowing complaints. What it does is guarantee protections for those who raise complaints, but its scope is also quite limited. It only covers those who amount to a worker, so it doesn't apply to things such as those parties in the supply chain or people connected to workers, and only where they suffer detriment and obviously have to bring an employment tribunal claim. As I said, the FCA and PRA have put in this additional layer of requirements, and the reason for that is because in the financial services sector, it's considered that there is a very clear potential for very serious wrongdoing, such as insider trading, financial fraud, money laundering and corruption, which could undermine the integrity of the financial system. So these additional requirements on financial services firms are intended to promote a culture of openness and transparency with the aim of detecting issues early on and being able to address things before they become really serious misconduct. And some of the requirements we've set out on the slide, they include effective arrangements for disclosure of reportable concerns, written whistleblowing procedures, the requirement that anonymous reporting must be accepted, and also in some firms they have to appoint a whistleblowing champion, which is a senior individual who has overarching responsibility for ensuring the integrity of the firm's whistleblowing processes. So just moving on to the next slide, and looking at what, if any, impact the EU directive is having on the UK regime. So the rationale for having these extra rules for financial services firms is really similar to that in the EU directive. But what the EU directive does is take this a step further and go beyond just financial services, but also look at other areas where there could be serious potential for harm, including the sort of the environmental sector, or sectors where there's a heavy use of data and data protection might be an issue. And I think what will be really interesting is to see how that potentially develops in the UK as we watch Europe moving potentially ahead of us. So just to draw out a few key differences comparing the UK regime to the regime that Sarah described. Firstly, in the UK, the protections apply to companies regardless of size, whereas in the EU there are size restrictions before you meet the threshold at which you have to have whistleblowing processes in place. Companies with 50 employees or more. So that's an immediate difference. There is also a difference in terms of the protections of who's covered. So I mentioned earlier that under PIDA it just protects the worker, and worker isn't defined in an extremely limited way. It does include employees, trainees, and consultants. But crucially, it's different from the European law in that it doesn't cover people such as volunteers in an organisation. It doesn't cover self-employed people or, crucially, non-executive directors, nor does it cover anyone working in the supply chain of the firm, which is a crucial difference, that those people are covered under the European directive. And protection is also extended to those people who have assisted a whistleblower in the reporting process, and also those connected to them, such as family members or colleagues who also potentially could suffer retaliation. There is also a difference in the sanctions. So Sarah mentioned that in some member states they've implemented criminal sanctions. That's not the case in the UK. And in order to report to the regulator in the UK, you also don't have to meet those conditions that Sarah mentioned earlier either. So moving on to the next slide and just looking ahead at where the UK might go, it's a little bit uncertain. We've seen over the last few years a number of private member bills in Parliament in relation to whistleblowing, but ultimately none of these have actually progressed into law. There is currently, you might be aware, a protection of whistleblowing bill that's going through Parliament, and if that was successful, then it would establish an Office of the Whistleblower and also repeal the current PIDA legislation and reform it. But at the moment, that bill doesn't have government support, and we think it's unlikely that that will actually go forward. It's currently stalled at the second reading stage and is about a year delayed, basically. Separately, Protect, the whistleblowing charity, is campaigning for a change in the law, calling for an expansion of whistleblowing protection to other groups, including, for example, job applicants and self-employed, and is requiring all businesses to establish minimum standards such as speak-up arrangements and whistleblowing lines. There is also, just looking at how the UK compares with the US system, there is some support in the UK for more of a move towards the US style system of rewarding whistleblowers. There are already 2 UK regulators who use this. So the Competition and Markets Authority offers rewards of up to £100,000 for illegal cartel activity being reported, and HMRC runs a reward scheme for individuals who report tax fraud. But on average, over the year, that has tended to only reward approximately £400,000 across everyone who's reported. So they're not huge. They're not huge schemes, and it's not widely adopted in the UK. In the financial services sector, the FCA and PRA consulted on this a little while back and ultimately decided that actually they felt it would undermine the whistleblowing mechanisms and what they were trying to achieve in that area. So it's not been adopted in that sector. In terms of moving on to look at just a few best practice points in terms of compliance. Sorry, Brogan, would you mind moving the slide on? Thanks you. So just a few final points to draw out. Good practices that we see and that we would recommend, regardless of whether you're in the financial services sector, would be a very clear written whistleblowing policy, some clear reporting lines so that everybody knows what they do when handling reports and how they report themselves. And also planning ahead and thinking, what are we actually going to do if we get a whistleblowing report? Having a plan for how you will investigate and a structure for dealing with them is really, really important to ensure that people aren't put off reporting because of how something's handled. And then also setting out and being really clear about the protective measures that will apply to whistleblowers, having a think about what you are actually going to do in practice to ensure their confidentiality and make sure that they aren't the subject of detriment or retaliation. And then finally, just thinking about training. It's really key to have all of the things I just mentioned, but you also need to make sure that everybody understands how to spot a whistleblowing and then also how to deal with it. Sarah was actually involved in a really huge FCA investigation, a key issue of which related to specifically people's understanding of spotting whistleblowings and also what you can and can't do when you're dealing with one. So it's not necessarily an easy area. Finally, just thinking about encouraging reporting. I think it comes back to this question of why do you want, as a business, you've got lots of costs and lots of different things to do. Why do you want to do this? And certainly from the perspective I come at, where I've seen dawn raids happen off the back of whistleblowing to regulators where people felt that they couldn't raise things internally, I would say that there's a real benefit in identifying issues and nipping them in the bud really, really early internally. It's far better that you get reports on your internal line than that someone goes to the regulator, because that is a much harder situation to handle. So it's just looking at things like, well, how do we encourage that reporting then? How do we really sort of embrace that? Because obviously dealing with reports and putting in place whistleblowing lines isn't necessarily the easiest thing to do. So it's thinking about making sure that people don't fear retaliation and sort of looking to embed a compliance culture where people want to challenge misconduct and compliant behaviour is rewarded, and that people have, crucially, they have a really effective means to report that they trust. That's all I was going to cover. We're obviously, I think, going to move on to some questions now.
Thanks so much. That was really certainly very interesting for us, and I'm sure very interesting to everybody listening as well. So the first question that I wanted to ask was just one that was, could you please repeat the list of the member states that don't permit anonymous reporting under the EU directive?
Yes, of course. Sorry, it's Bulgaria, Latvia and Lithuania.
So I'd be really keen just to hear again a little bit more about, in your experience, what would the impact be of implementing an external whistleblowing channel? Question to Dentons, please.
This is to us. Do you want to go first?
Yeah. So the effectiveness of anonymous reporting is found in understanding your drivers for reporting. And for most companies, it won't be because they have employees that don't care or that they don't identify issues. A lot of it comes, in fact, from really good, positive firms that have a strong culture and have strong bonds within their teams because they don't want to be seen to be disloyal, or they're concerned about being othered from that group. So there'll often be a reluctance to report for that reason. So we've found that actually providing this anonymous reporting system permits the confidence or empowers employees to make reports in circumstances where they may have felt reluctant to do so, not because they didn't want to, but because they were concerned about the impact on them. And as I said, that happens in a lot of good firms, and it's happened recently for one of our clients, hasn't it?
Yeah, no, and I think that's the thing. It's really easy for, you hear clients often say, "Oh, but we don't have any issues." And they often don't have a reporting line as well, or they don't have an external reporting line. And they say, we're not really having any issues. But we've seen a client of ours where they have got that really tight knit culture already, and it's everyone likes there's a good culture there on the face of it. But then equally, what we found when they decided that they should implement an external line was that their visibility of issues just increased dramatically, and there was a real increase. There were things coming out, but that's that they wanted that was kind of what they wanted, to get under the skin of things, and it's been really positive for them to be able to actually address those issues,
address some long-standing issues that they weren't aware of,
and move forward basically. So I think there can be that sort of initial period where you think, oh my goodness, we've done this, and actually we've got some reports to deal with. But if you step back and think about what the alternative is, which is that people leave because they don't feel like or they go to the regulator, it's so much better to have those things aired and dealt with.
Thank you. And yeah, I think as I said earlier, I think a lot of our clients certainly want to understand what's going on, and just to make sure that they can improve their culture, and I think that absolutely does help with that. I've got a really interesting question, which is slightly different actually, which is, if somebody raises a general kind of whistleblowing matter, but is also potentially subject to a disciplinary, how should that be handled? How should those two things be handled?
With a lot of caution. So it's a really tricky one. It's a really tricky one because it's the idea of the fallacy of the perfect victim or the perfect witness, right? They don't exist. Just because somebody is a whistleblower doesn't mean that they are unproblematic or that they haven't caused issues in other ways. And it actually came to the Court of Appeal last year, an incident where a whistleblower had correctly reported an issue within their firm, but reported that issue in such a way that they were aggressive, they were hostile, they were rude, they were intimidatory, and they were subject to disciplinary action in respect of the way that the whistleblowing complaint was raised and the way they dealt with it. And what the Court of Appeal has said is that they'll have to consider the mind of the decision maker. So, of course, a person cannot be penalised, cannot be dismissed on the basis of their whistleblowing report. But They will consider the operating mind of the decision maker, and if it's clear that the disciplinary action was in respect of behaviour which could be separated from the report, then there is not an issue there, and the protection don't apply. So document it, make it very clear, be cautious, and I don't want to plug us at all, but seek legal advice.
Yeah, trying to make sure that you manage things and separate things out as much as where it's appropriate to do so. Potentially different people involved in different decisions, and like we operate, you know, under that sort of Chinese walls principle. Sometimes that's the sort of thing that you may need to adopt in that situation. But Sarah says just really careful thought about it, and handling it right from the outset is key.
Thank you, that's really interesting.
Thank you so much. And we've had a question come through in the chat that I would pose to Dentons again, as the experts on this one. Can a company use a UK reporting channel for EU-based employees?
So this is about how you structure your whistleblowing framework, right? So we're going to have a think about how you want to approach it at a group level, and it's the same as any financial crime compliance policy or broader compliance policies. You can put in place a framework that covers multi-jurisdictional operational offices, but you have to be very careful, and you have to make sure that you are meeting the requirements in each of your operating jurisdictions. So have a look at what is required. It takes some work at the outset. Look at the requirements for each of your operating jurisdictions, and if you want to put in place a group policy, you would find the highest requirement in each of your jurisdictions and set your policy there for everybody. Now that can take some buy-in from people in local jurisdictions, particularly where their requirements are much lower than in other operating jurisdictions. But I think, I'm sure Katherine agrees with me, that with something like whistleblowing, putting in place those additional protections and requirements can almost never be a bad thing, right?
Yeah, going to that highest requirement is likely to be helpful in the long run. There's one other consideration, I think, with this as well, which is around data protection as well, and sort of understanding if it's a UK whistleblowing line, where is data being held and where is it being reported into, and just thinking about what that means in terms of local requirements and whether that is an issue or not, to handle data in that way. And then also looking at how that matches up with the privacy notice and that you've put out, saying how you're going to handle data when it's reported in that way. So there is that extra layer, unfortunately, there always is when personal data is involved, but it is potentially surmountable. I don't know whether there's anything you wanted to add on that.
Yeah, I think absolutely. I mean, there's lots of questions coming through which are of a similar vein actually in the chat, and unfortunately we're not going to have time to answer them all. So what I would say is that for those that we don't get to, because we've only got a couple of minutes left, if you have given your details, we will come back to you individually to give you feedback on those questions. And if you have put it in anonymously, if you do want to come back to us and ask us it, you know, directly, then please do. So our contact details will be published after the event. But yeah, I mean, we get asked lots of, as a provider, and one of the reasons we wanted to have this webinar today is that we get asked lots of questions around, you know, data protection and around helping companies be. We get asked a lot, do Safecall using Safecall make a company compliant? And I think the really interesting point there is that our services enable the company to be compliant, so our software and what we do enables them, but ultimately the onus is on the organisation to understand the requirements and to implement the correct and decide what they want to do, to your point, I think, Katherine. So I think the thing I would add really on that is that if organisations are concerned about whether they are adhering correctly to them, and as we've seen today, there's lots of things to think about, then perhaps reach out to somebody like Katherine or Sarah and have that conversation, just, you know, if you want to have the reassurance that you are considering all the right things, because as I say, there is a lot to think about. I just wondered, given that we're kind of 1 minute off, sorry that we couldn't get to everyone's questions, but it's great to have had so many attendees and so many questions. And like I say, we will come back to you if we can, if we've got your details. But just lastly, Katherine or Sarah, is there anything that you wanted to add before we finish today?
I think that just my key takeaway would be that the real benefits of getting under the skin of things and avoiding issues coming to light, avoiding people going to regulators. We often see the other side of that, where it goes wrong, and when it can be really, like, businesses really find themselves on the back foot then. So I really can't stress enough the potential benefits of being able to get to it. It's like a privilege, basically, to get to deal with issues internally rather than ending up under investigation.
Yeah, effectively report and effectively triage, I think, is the key, right?
Yeah, definitely.
Thanks so much. Thank you very much for joining, everyone. Hopefully that was useful. Please do follow up with either ourselves here at Safecall or directly with the Dentons team if there's any more that you'd like to understand about this area. Thanks very much and have a great rest of your day.
Thank you.
Thank you.